Yeah.
Recording.
We're live. Good evening, everyone. This is attorney Robyn McCoy and attorney Tracy Wright. I'm sorry, Tracy. I'm gonna
must have
repeat
been
it.
a long day in court.
I know. I'm gonna repeat it because we're gonna edit it. Okay, you guys. Good evening, everyone. This is attorney Robyn McCoy and attorney Tracy Martin with Politico Coffee, with Robyn and Tracy. And we have our special guest today, legal expert Stuart Friedman. And so I'm going to turn it over to Tracy.
Yes, we're very honored to have Stuart G. Friedman with us tonight. This is a special edition of Politico Coffee, the official podcast. And we're going to be talking with Stuart Friedman, the super attorney, about pardons and clemency law. You know, what's the difference between presidential pardons versus gubernatorial pardons? I know a lot of people have a burning question about Bobby Ferguson. You know, Kwame Kilpatrick, he got his sentence commuted. Will Bobby Ferguson ever have a chance? So I am going to be monitoring for questions on our Political Coffee Facebook page. If anybody wants to post anything up, I will be looking for that, and we will pose a question to attorney Stuart Friedman, who we're very thankful that he could join us today because there's so much happening in the law today. And we are going to, I think, discuss the Minnesota versus Chauvin verdict later on in the broadcast. And Robyn, I did bring with me my mug today, my special Senate mug, because I'm asking everybody to call their U.S. senators to support the George Floyd Justice and Policing Act 2021. It is H.R. 1280. And I've got coffee in my mug. I need that afternoon fix.
Yeah, so welcome, Stuart. Welcome with us today. So what mug do you have? What do you have?
This is actually just one from the College of Science and Technology in Trinidad, which is one of my wife's clients.
Oh, well, show it to us. We can't.
Yeah,
really
show it to the audience.
But it is sitting in my genuine U.S. Supreme Court coaster, so.
Oh, okay.
Nice.
And
Cool.
I've got, as we're seeking justice, I've got Batman, and I've got my Robos tea, Red Bush tea. As the audience know, most folk know, I lived in South Africa, and so Red Bush tea is very healthy tea, and honey and lemon. And Batman, with again keeping in line with the concept of justice. That's what we're about, is justice. We saw some justice yesterday, and hopefully we can keep with the momentum. And so for the audience, Stuart, I'm briefly going to just give them some of the highlights from your bio. I would say I've known you for a number of years. I consider you're like the expungement pardon guru. You're our go-to person when we want to get the 411 about expungements, pardons, things of that nature.
Yeah, he's got a 7-page curriculum vitae and very impressive. And so, yeah, Robyn, take it away. Tell them about
this. So attorney Friedman has a specialization in criminal appeals, post-conviction relief, collateral consequences of criminal conviction, U.S. immigration law, including appeals, removability, admissibility law, with a focus on crimmigration, that's a new word, northern border issues, waivers, September letters, NAFTA, Kuzma work permits, snowbirds, U.S. citizenship renunciation, and spousal visas. Admitted to practice by State of Michigan, U.S. District Court Eastern, Western District Court of Michigan, U.S. Court of Appeals for the 6th, 7th Circuits, Board of Immigration Appeals, including admission to the Executive Office of Immigration Review. So let's see, he's admitted to the appellate practice section for the State Bar of Michigan, American Immigration Lawyers Association. So I'm sure you probably know Cindy Nunez and her partner, Criminal Defense Attorneys of Michigan, Immigration Section, State Bar of Michigan. Let's see, Citizen and Immigration Section for the Ontario Bar Association. I know you're going to talk about what you can do for folks in Canada dealing with Canadian issues. A member of the National Association of Criminal Defense Lawyers, member of the Ontario Criminal Defense Lawyers Association, associate member, Canadian Bar Association, Ontario, member of the Ontario Bar Association, and the Prison and Correction sections for the State Bar of Michigan, active with or cooperating attorney with the Cooley Law School Innocence Project, taught a wide range of seminars, defending prosecution, parole appeals, Michigan Expungement Coalition, moderator, Michigan Appellate Bench Bar Conference, 1995 to the present. I know we recently, Black Women Lawyers, had on February 4th. Yeah, we had an expungement forum, and we had Stuart as our honored guest and expert for that event. And so he's got some publications: Broken Record, Crossing the US Border with a Canadian Criminal Record, for the defense, 2016. Chapter author, Michigan Appeals Institute for Continuing Legal Education, 2013 to the present. Columnist, Stu's Tech Talk, Michigan Appellate Assigned Counsel System, past editor, Prison and Correction Section newsletter, and Friedman host Hot Issues and Parole Appeals, Prison and Corrections Forum, summer 1998. So, again, the Michigan parole, hurdling the 6,500 barrier. It ain't over till it's over, defending prosecution parole appeals, government math, O'Hare versus Department of Corrections. What is this? Also, Gerard Bush and Friedman, prosecution appeals of decisions to parole. And so as far as education, Wayne State University Law School and Bachelor of Science, Wayne State University. He's had some awards and acknowledgements. Marquise Who's Who 2019 Super Lawyer Recognition. AV 10.0 recognition, LinkedIn. AVO, okay, AVO. LinkedIn top 1% of peer recommended appellate lawyers, Crane's Michigan Best of Detroit Lawyers 2016. So yes, so we have, again, our legal expert, Stuart Friedman, here to talk to us about expungements, pardons, and we're also going to talk about the George Floyd Policing and Justice Act. So welcome, Attorney Friedman. And can you tell the audience what motivated you to become a lawyer in the first place?
I was on the other side. I served several years in the state prison when I was very young. I was involved in a commercial auto theft ring. And with time on my hands, I started studying the books, got out, found the Detroit bar quite accepting at hiring me. I worked as a law clerk for James Thomas, who represented Kwame Kilpatrick, which you were just talking about. I worked for a number of the most prominent attorneys in Detroit at the time, and I found them very accepting. So by the time I finally did get into law school, I had no doubt what I wanted to do. And Michigan has one of the more liberal rules about second chances with criminal records in terms of professional licensing in some fields. So in 1991, I got admitted to practice. The state took extra hearings, but the state admitted me. And I've been doing it ever since. And I try to remember where I came from. And I have represented people since that time. In 2010, I became lucky enough to be one of the very small number of people in the state of Michigan to get a full governor's pardon.
That's awesome.
The day it happened, with having probably have the least amount of disabilities of anybody with a record, it's still, I remember the moment. I, at the time, was probably 20 pounds thinner and was running a lot more, but I still did the best run in my life by about double. The energy just propelled me, and having a criminal record, even if you do succeed, is like having a cancer that is at that moment in remission. It may disappear, you may forget about it, but it does pop back up. And it's something that will always pop up at the worst possible time. So it's something that has very much kept my eye on that ball. I focus, and my passion is still really everything that happens after a criminal conviction. I went into the immigration half really to deal with the fact that too many of my clients were getting deported particularly after 1996, when Congress passed some really horrendous laws called IRA in particular, that made it so that if you had a criminal record, you were pretty much looking at getting deported. And it wasn't a Republican who passed that, it was Bill Clinton. So,
Oh, and
yeah.
can you
Wow.
tell the audience, Stuart, how old were you when you had your troubles? Like, how old were you?
I wasn't old enough to drink. I was under 21. Last conviction was when I was 20. First
Okay.
one, first offense, I didn't get immediately caught, was probably 18. So,
Okay. So
too
so
bad. I had
relatively
2
young.
bad years, but boy, were they doozies.
Well,
Right.
Stuart, I have a question. So congratulations on receiving your full gubernatorial pardon. You said that was in 2010?
Governor.
And so remind me, was that under Governor Granholm?
Yes,
Okay, and did you, who handled that for you?
I did. I did
You
it
did it
myself.
yourself?
You did
Wow,
okay.
that's
That's
amazing.
But it was easy for me. I mean, first of all, I knew the law. Number two, I had all my friends who were mostly lawyers in the room as character witnesses.
Okay,
But I'm one of the few people who's really done more than one of these. So I knew my way around the block, and I had friends who used to work for the parole board who consulted with me. I had a lot of things going with me. I litigated against the Attorney General, who was representing the parole board on a number of occasions, and I knew the chairperson of the parole board at the time.
okay.
So,
And did anyone object? Did anyone object?
no.
great.
I
Okay.
didn't have the problem that a lot of people have, which is a crime of violence. I didn't have victims who, as much as it was annoying, I didn't have anybody who made it a passion. And when my offenses took place, we didn't have the victims' rights movement. So
Okay.
frankly, they didn't keep in touch with them, and many of them had so moved on. I think one of the problems with victims' rights is it encourages people not to grow scar tissues. We tell them that once you're wounded, you should stay wounded. And whenever a case comes back into court, prosecutors basically make the victims relive what happened, and then they blame the criminal defendant for their tearing off of the scar tissue.
Right.
I have to applaud the new prosecutor for Los Angeles, who's called that point out and said, perhaps we're not handling that correctly, but he's still in the minority.
Okay.
That's interesting. Well, there's been locally a lot of attention turned toward the former mayor of Detroit, Kwame Kilpatrick, who, as you know, received a commutation, I believe, from the former president, Donald J. Trump. This is, I think, a good time to talk about the difference between, in terms of executive clemency, the difference between pardon and commutation. If you could describe for the audience what that difference is, please.
Sure.
Right.
And this is the same whether it's the governor or the president doing it.
Okay, thank you.
Pardon wipes out a criminal conviction. It's normally given to somebody who is out, who has been deemed to be sufficiently rehabilitated that they're deserving a second chance. But unlike an expungement, which we'll be talking about later, there are no restrictions on the number of them that you can get. And there are no crimes that are excluded. For example, you can't get expungement currently in Michigan for drunk driving, but you could get a pardon for it.
Now that is interesting. You can't get an expungement as the law reads now, but you can receive a pardon. But what is the likelihood of the, for example, the present governor, Gretchen Whitmer, who did a pocket veto when it was proposed for first-time DUI offenders who, didn't injure or kill anybody to be able to get an expungement? I mean, what are the chances of actually getting a pardon for a drunk driver?
Let me, before we talk about commutations, let me give you the numbers on pardons.
Okay.
In 1969, we reset the clock
Okay.
because of all the expungement laws that were passed back then, HIDA, et cetera. So I want to start from 1969, which is 50 plus years ago, to today, and we are under 100 pardons granted at the state level. We're state.
Wow.
Yeah,
Okay.
so you're really talking about a last resort measure. And the big difference is you're asking a politician to stake their political name behind it. If you remember Governor Dukakis, and when he ran against George Bush, we had the problem with a gentleman named Willie Horton, not the Detroit baseball player of years past, but Willie Horton was given clemency. And clemency is an umbrella term that includes both pardons and a commutation, which is a sentence reduction. He was actually given a commutation, a sentence, and he went out and he killed while he was out on that commutation. And a very successful campaign was run against President Dukakis, who was Governor Dukakis at the time, for that one act. So anybody who thinks that they've still got a political career left in them is sitting there saying, do I want to risk having a Willie Horton out there?
Right.
And politicians love to say that they are brave souls, but I've known plenty of them and they are not. They are always very cognizant of the political fallout.
Yeah,
So-
it seems to me from what I've seen from pardons is that they're more often likely to do it when they're on their way out, like not up for re-election, but on their way out. I've seen it. I think it was in Virginia, there was a governor that did 1,200, and then I think California there was 1,200, but it may have been, maybe that's on their way out.
And the state numbers are very different from one state to another. And while I started this discussion at 1969, if you go back to the turn of the prior century, in the 1890s and very early 1900s, we had one governor who signed 200 pardons on his way out.
Okay.
But those are not current numbers. And if you look at a state like Georgia and you compare it to Michigan, Georgia signs plenty of them. But they removed it in Georgia from the governor and gave it to an independent board, which is a different creature. It was meant to remove the politics from the process. Because one of the other problems we see is that pardons are often very, very political.
Is that the difference now, Stuart? Because as I understand it, based on my research, yes, going to what you said, that at one time in this country, pardons were done with a frequency and they didn't have all of these layers of review that applicants, petitioners have to jump through. And based on my reading, at one time, I think it was a Johnson or somebody who pardoned an entire Dakota tribe for killing people, and everybody who fought in the Confederate, the war, the Civil War for the Confederates, they got pardoned. So is the difference now the hyper partisan political times that we're living in terms of getting these pardons?
Well, there's a difference here between the state pardons and the federal pardons, and I think I probably should drop into that a little bit.
Okay, yeah.
Under Michigan law, the governor has to do it with the advice and consultation with the parole board. It's the legislature can pass statutes regulating the process as long as they don't really cut it off at the kneecap. So they couldn't pass a law that purports to regulate it, but actually regulates it out of existence.
Okay.
At the federal level, there's a whole procedure through the office of the pardon attorney, but the president can totally bypass it. And President Trump regularly did it. One of the things that you're watching with is that if you hired Rudy Giuliani or Alan Dershowitz as your attorney, it went directly to the president, it bypassed all this, and it gives it a taint. But it's still a full-blown pardon. So politics matters a lot more at that level. Now, I'm not saying it doesn't at the state level. You asked about drunk driving pardons, and Governor Snyder gave one to an executive in the Michigan Chamber of Commerce, and the OUI was a very fresh case.
I recall.
Under 10 years old. The average time for a pardon that's based on rehabilitation is well over 20, sometimes 30 years. My pardon in 2010 was for 1980s crimes, and I'm one of the younger people to have gotten them. So think.
Okay.
Usually when you look at the statistics as to federal pardons, you're looking at people whose convictions are 30, 40 years old. Many of these people are getting them, who get them are already collecting Social Security or more for crimes that they committed as young men or women. But when you talk about the political ones, it's a totally different story.
Okay. And Stuart, can you tell us, because Tracy and I, we did write, there were some of us lawyers that wrote a letter to request that Kwame Kilpatrick be pardoned, and we see that he got clemency, but he did not get pardoned. And we know that there's the First Step Act out there. You know I also added that on a request to pardon and grant clemency to more of the people that are in the federal system. And can you tell the audience, like, what would need to be done? Like, okay, Kwame got clemency, but what would need to be done for him to actually get a full pardon from, it would be now President Biden, if they were going to pursue that? What would they need to do?
Well, the normal process is that you file with the Office of the Pardon Attorney inside the Department of Justice your request. And the request contains their form, followed by all your reference letters, everything that's good in your life that you can show. So certificates of accomplishment, diplomas, transcripts. Expect that they will look at and run a credit report on you. Bankruptcies hurt. Long, stable community connections help, etc. Normally, most pardons are based on rehabilitation. Now, the president can also grant a pardon based on innocence. And here there's a slight difference between Michigan and the federal system. In Michigan, we have the 6500 motion, and you can file more than one in exceptional circumstances to get your case reopened if you've got new evidence of innocence. In the federal system, you've got a 3-year cap on when you can file a motion for a new trial based on newly discovered evidence. And you've got very tight rules on when you can file what's called a 2255 petition to reopen a case after, based on errors that have happened that aren't in the record referring to the court file. So if you think your attorney was ineffective, etc., that would be a 2255. If you've caught the government hiding evidence, that would be a 2255. And the rules are exceptionally narrow once you get out of either the 1-year time limit for 2255 or the 3-year time limit on a motion for a new trial based on newly discovered evidence. We don't have those. So the general rule is that they want you in Michigan to take it to the courts, that very often a governor will turn around and say you haven't done that first. Now, a governor is fully allowed to grant a pardon for actual innocence, but I'd like to go back to Governor Granholm, and if we all know Mr. Kress and the newly discovered evidence test, his petition for a new trial based on newly discovered evidence was championed by Assistant U.S. Attorney Jennifer Granholm before she was Governor Granholm. And he initially won, and the Michigan Supreme Court, a much more conservative Michigan Supreme Court, took it away from him. When Governor Granholm got the file, she gave him a commutation. She ordered him to be immediately released, but she didn't remove the taint of the conviction. So she wasn't quite that confident. And one thing is that in most cases, remember that a president of the United States is normally a person's last job. Governors go on to become senators. They go on to run for president, unless you're born in Canada, like Governor Granholm. And then even then, she's looking at a cabinet level position right now. So
Right.
it reaches back to haunt you if you've made a mistake, much more so. So there is a huge difference there. Will Kwame Kilpatrick eventually be able to get a pardon based on rehabilitation? Yes, but he's going to need to go out and do a little bit on the streets. He's got to do some charitable stuff. He's got to get his detractors a little bit farther in the dust. And remember, we amended the Michigan Constitution to stop Kwame Kilpatrick from running from office again.
Right.
So don't minimize the number of people who are on the other side of that. And I hope that Mr. Ferguson gets a commutation as well. I think that to paraphrase the Sixth Circuit in a different case, we're sick kittens caught in a tiger trap. I mean, you're talking about things that were drastically overpunished. I mean, that's the problem with the federal system, is that they can wait for years, add everything up, and then absolutely throw you the key away. And often the criminal conspiracy they were chasing after is history. The people have moved on. And it is so easy to get caught into a conspiracy by accident. And I can't tell you, I represented a gentleman named Ronald Zajac, now deceased, who was the attorney for the pension board. And he got convicted because he hosted a couple of parties for people where contributions were made.
Is that why he was convicted?
Pardon?
Okay. That's why he was convicted, huh?
Yes, he stood in on one business trip as well, but they never found misappropriation of any monies. They found he didn't have a vote. And the pensions did well. The Detroit pension during that board was actually higher performing than many other pension boards at the same time. So you might say, well, we should have given the contract to this casino rather than that casino of a very small group of risk funds, but money really wasn't lost. And it was the borrowing into the pensions, and it was a lot of other things, but that's the stuff people don't hear. People do move on, though. And I think the thing with pardons is that we don't hear about the successes in the criminal justice system. We only hear about the failures. We hear about the person who's committed a new offense when they're out, or multiple offenses. We don't hear about the people who have just gone back and gotten a job and moved on, or gone to college, or have gotten married, aged out of the criminal justice system and have never gone back. That's the stuff that's never told. And I think that's what we were targeting with the Clean Slate Initiative as well. I mean, is the recognition that so many people have got skeletons in their closet that have been in that closet growing cobwebs for a decade.
Right. And speaking of the clean slate legislation, Stuart, can you tell the audience what is the new legislation, just generally, like, what does it do? And
well, I'm painting with a very broad brush right now.
Okay.
But it increases the number of felony convictions you have. It used to be you could only have one felony conviction. Now you can have up to 3. Now, life offenses are excluded, as are several other offenses. I don't want to go into all of them right now. It allows you to expunge an unlimited number of misdemeanors. It goes after what I regarded as a pernicious problem that prosecutors exploited, which was under the old law, you could have multiple offenses that happened at the same time, and they would insist on 2 convictions just to make sure somebody couldn't get an expungement. So somebody breaks into something with a screwdriver and they insist on a conviction for possession of burglar's tools and the underlying breaking and entering, just to make the case expungement proof, because prosecutors would look at an 18-year-old and apparently have a crystal ball and be able to determine that person wasn't worthy of a second chance 20, 30 years down the road. The Clean Slate Initiative also includes marijuana reforms, which are important. Basically, any use-related offenses or possession-related offenses can get wiped out on that on a summary procedure where there isn't a court hearing in 95% of the cases. We're not talking here about dealing where it's handled differently. Sale of paraphernalia is considered possession, not sales, for purposes of what I'm talking about. It did not include, unfortunately, however, drunk drivings. We're hoping to see that this year. It's probably going to be only one drunk driving that can be expunged at first, but there's some potential down the road, if there's no disasters, for that to increase too.
Right. I think
So there is hope.
that would be very hopeful, because, I know people that have had one drunk driving. It was 10, 20, 30 years ago. They haven't had a new offense. Then you compare it to my clients that have like 5 drunk drive. That's different. Okay. In a short period of time, that's a different scenario than a one-time scenario, 20, 30 years ago.
Stuart, I want to return to the federal clemency process. And there's a very good article out there in the appeal from January 2021, and it's written by Sean Hopwood, and it's entitled "How Joe Biden Can Fix the Broken Clemency Process." As a noted authority and an expert on clemency, I mean, do you think that assessment is on target? Is it really a broken process? There are some criticism.
I think it is a broken process. And Professor Hopwood, like myself, has been on both sides of this fence. He's now a professor, I believe, at Georgetown. Okay. And he was a former bank robber. So another example of somebody who's turned it around. But yes, I mean, we've introduced bills for federal expungement forever, and they get buried in committees. And I think that really needs to be our first step. With the exception of some really, really obscure things, you can't get a federal expungement. I mean, maybe
it just doesn't exist. You can't get it, period, right now.
Right. There's an exception for youthful drug offenses that are committed in weird places. So if you get caught smoking a joint when you're 17 in a federal park, maybe, but that's the exception that probes the rule. What happens then is that we push everything up to the president, and presidents don't do this until they're close to the end of their career in most cases, because of the fact that there's so much political liability. They may be running for re-election, etc. I mean, there was a joke that it was a constant joke that the only pardon that a president signs early in their career is for the Christmas turkey.
Okay, that's a good one. Yeah.
So then, as we get near the end, in the pardon attorney's office, and you're stuck. You can only apply every 2 years, I believe it is. So what happens is, towards the end, they get flooded. Now, let's go back and let's use President Trump as an example.
Okay.
Everybody for a long while thought he was going to get reelected. No, it took a confluence of a lot of things for him to get thrown out. And however happy we are that we had the largest defeat ever in terms of numbers, we should never forget that he had the second highest number of votes ever for president. We only managed to win because of the exceptional turnout, which is why, of course, the Republicans are trying to make it more difficult to vote. But what happened was, because everybody thought that he was a shoo-in for re-election. It wasn't until people started seeing the writing on the walls that everybody flooded the pardon attorney with requests. And then everybody with money turned around and bypassed the pardon attorney. I believe that
What's wrong with that? What's wrong with bypassing the pardon attorney and going straight?
It's political clout. If you can pay $250,000 to hire Rudy Giuliani, which I've heard through multiple circles is what he was charging.
Really? Wow.
I mean, I'm not going to begrudge you. More power to you in one sense, but in the other sense, a lot of meaningful people were passed up in the process.
I see.
And it becomes an absolute circus in those final days as they're trying to figure out which ones they're prepared to grant. And it really shouldn't depend on whether or not you've gotten a $50,000 a year job as a welder, or you're very, very fluent. I mean, it really turns on how you've gotten that money. I mean, Bernie Madoff was trying to be one of those people.
Oh, yes, I understand he was. Well, we know what happened to Bernie Madoff. He passed away recently. But in fairness to President Trump, I mean, he also pardoned someone like Alice Johnson. Of course, she had a celebrity champion in the form of Kim Kardashian. But I do understand that the POTUS 45 and his daughter Ivanka Trump were going all the way almost up to midnight to process these pardons before he left office in January of this year. Is that what you heard?
It's absolutely what I heard. And the fact that they were going through that at that last moment probably means that the ones they were processing were the ones that hadn't been vetted by the pardon attorney. And it's the big problem is cutting in line. Okay. We all stand in lines and see the little bypass that says if you're an elite status, you can walk around to the front. And the problem is that when you've got 100 people who walk into that line and you've been standing there for years, right. That's where the unfairness is. The other thing is the president, frankly, really doesn't have a lot of insight into it. You want to have, and who prepared the counter investigation? If you go through the pardon attorney, an FBI agent goes out and does an investigation. Parole officers or other individuals in the Department of Justice will investigate that. When Dershowitz or Giuliani drops a file on the president's desk, who's going in there and saying, well, here's what we're not telling you about? Okay. So it's a very one-sided process, and it's very easy to manipulate. One of the problems that happens also is that if you get a lot of money, it's real easy to stack up a few charitable works, a donation here, a donation there, and you can get plenty of letters. You can get wings at a museum named after you, but Taubman did that while he was still embezzling money. Madoff,
he got a pardon, didn't he?
I believe. But Taubman also had a lot of charitable works named after him while he was still committing a lot of his fraud. Madoff certainly did. Madoff had a wing in a hospital named after him. Right. And he paid for it with other people's money.
Do you happen to know off the top of your head how many pardons former President Obama granted before he left?
Not off my head, I'm sorry.
You don't know? Well, one thing that I do want to bring up is that when President Obama was president, I understand that Sally Yates often made blocks. She blocked petitions for pardons, and that is a criticism that the Department of Justice has. They allow prosecutors to have too much influence in the process, and it was said that the reason why Sally Yates was doing the blocks is because prosecutors were saying, no, don't let that petition for pardon go through.
I'm looking, I did want to briefly respond because we do have the internet. So I'm looking at the fact tank real quick. It says that Trump granted 237 acts of clemency during his 4 years in the White House, including 143 pardons, 94 commutations. It says his predecessor, Obama, granted clemency at 1927, 1,927 times over the course of 8 years in office, the highest total of any president going back to Harry Truman. Obama's total was skewed heavily towards commutations, which was 1,715 instead of pardons, which was says 212. So I'm sorry, Stuart, you were going to respond to something that Tracy said.
I'd rather move on if you don't mind at this point.
Okay. I wanted to go back to expungements. So I know for expungements, for the misdemeanors, it's 3 years for misdemeanors. For the first felony, it's 5 years. And then second felony, it's 7 years. So then, I mean, they don't say it, but I'm assuming what the third felony is 7 years as well. Is that correct? Okay. And so, you know, I did have the application. I mean, actually, I could probably let's pull up the application real quick because I know people are looking at it. I'm getting calls. We have the application here. It's a little bit different than the other application. You have to put your the case number, the judge, the name of the client, a defense attorney in there. I see this first section where they want you to put things in here, and I see what's a little bit, and they have questions. Then I see this second and the third and fourth section. And Stuart, have you had a chance to look at this? This third and fourth section, do you put the same things in there as like under the first section, or is this for additional crimes? Is it because we have the increased number?
You put down, if you would have looked at the original form that they replaced, it would have had a space for 1. Here you put in the name of the crime, and you put in the Michigan Compiled Law site, which people can find at michiganlegislature.org. You're going to have a harder time finding the PAC code, which is the prosecuting attorney's code. But I don't think that judges will seriously hold the absence of that against you. You want to have the date of your conviction, which is the date that you were found guilty, not the day you were sentenced. And you want to have the case number. You want to then turn around and note below that you want to have more than 1 conviction set aside. And you want to look at the definitions, and more help material is going to be coming out. A lot of self-help materials are just in the pipe. And if you look at this form, you'll see that it was released just before the law went into effect on April 11th. So it was very late to the table. So there is a lot of people who are still coming up to speed. My first couple ones that went out, I actually had to put out in a homemade form because of that. And I hope it doesn't cause them any problems, but we were facing some collateral consequences where we couldn't wait. Misdemeanors go below. Now, if you go back up, you'll note there's actually 2 things that aren't covered under this. The first one is the marijuana ones, and I don't see a notation, but I believe the violence against women's ones exception is on a separate form as well. Please don't hold me to that one.
Yeah, no, it does say on here, it says if you're asking for a conviction set aside, it says because the offense committed was a direct result of what it talks about victim of human trafficking, you've got to use form MC 227B. And then if you're asking to have a misdemeanor marijuana conviction set aside, you've got to use MC 227A. So, but again, we know that there are folks out there that are trying to figure this out. So I see we have this first.
You should go back up also and note the box for multiple convictions that needs to be ticked in the top right corner.
Okay.
As well. And if you don't have an attorney, you want to turn around under the section that says attorney and just write the words in pro per, IN space PRO space PER.
Okay, and then I see you have this, they have the second section here. You can go through like the different situations. I'm requesting more than one felony to be set aside.
Correct.
I'm requesting one or more serious misdemeanors. I'm requesting one felony to be set aside, or I'm requesting one or more misdemeanors. They have that distinction. That's it's different from the other form. But then when I was looking at this today, because again, I've been flooded with calls, folks were, getting the applications in order. You have this section 3 and 4. Is that a repeat of what you have in that other section, or is this just more space for more offenses?
No, if you've got more offenses, you put that on a separate piece of paper. If you look at this, it says no other application has been filed to set aside a conviction listed in item 1. An application was previously filed to set aside the following convictions listed in 1. So these are if you've got a prior denial.
Okay.
And one of the things that I'm going to go off topic here and say is that if you're going into court and all of a sudden you're hearing that there are things that are wrong with your petition, you've got problems with the judge, you sense the judge is going to deny it, you are much better asking for permission to either withdraw it or ask that the petition be denied without prejudice.
Okay.
So if the judge is saying, I don't have enough information here today to decide it, you want to kick the can. You don't want to sit there and say, I still want to take my best shot. If you've got a prosecutor you're representing yourself and the prosecutor is showing up with a bear hunting rifle, armed, locked, and loaded, you can do that. You could also say, Your Honor, I didn't anticipate that the prosecutor would be coming in here or fighting me in this fashion. Can I please have an adjournment to get counsel? And most judges are going to say yes. And if you look at the section that you went down below, which would be, I believe, 4, it talks about ones not considered in 1. So an application was previously set aside dealing with the following convictions not listed in 1. So if you've expunged a conviction elsewhere, if you got one denied elsewhere, that's what they want to know.
Okay, and then I see that they have the section 5 where they want you to list or say whether you've had a conviction deferred or dismissed, and then you list out what you've had deferred or dismissed, and that there's no other criminal charges pending against me. I mean, most of the folks that have reached out to me have old offenses. They don't have pending cases, but obviously that's a problem if they do. I see that they still have the same thing from before. The applicant signs it, they have to have it notarized. And then I see that they have the further section where the notice of hearing, where for the prosecuting attorney, judge, location, the proof of service, you got to send it out to the prosecuting attorney, attorney general, state of Michigan. With the fingerprinting, I am seeing some people are encountering difficulties because some of the police stations are closed or they're not as open readily because of COVID. I know that the state police, they said that the Brighton office is open. The second precinct in Detroit is open. Sheriff Clayton in Washtenaw County, they said that they're open to doing clinics like where people can come in and get free fingerprinting. So that's helpful. But I would say, Stuart, like in looking at this application, and I see that they do have some of the directions here for everything. What would you say are some of the glitches that you see in this with this new legislation? I mean, it's good, it's more expansive, but then there are some glitches.
Well, what people need to know is that this is really a confluence of, I think, 5 different bills that came together. So there've been some drafting issues. One of the questions right now that we're seeing some discussion on is whether you need to file on your last conviction first. It's an open question, but there's an argument in the statute that you should. So right now, until it's worked out, that's the way I would recommend that you go. Another thing that we're seeing is some discussion about the one bad night provisions. The one bad night provisions say that you can have, that sometimes one conviction can actually mean 2 or 3 convictions if they rise out of the same transaction, but then we've got an exception for firearms. But exactly what the same common transaction is going to be a point where attorneys are going to be arguing. And if your case really comes down to that one, if there's any way you can afford an attorney, I really suggest you do, because that's the kind of an argument where I think a lawyer is going to do way better than a layperson. I'm going to also at this time break a little bit to the side to say, know your record backwards and forwards before you even start. When you talk to people who've got 20 or 30-year-old convictions, sometimes they'll miss things. Sometimes they'll remember things wrong. You can get from the state police for an in-state conviction a printout if you send it yourself, not through an attorney, not through any third party. You can request a copy of your record, including all expunged and deferred convictions. So you can get a printout of what's out there. So if there's something out there that you forgot about that's out that could get in the way, you need to know about that. If you've got a prior conviction that was taken under 7411, the drug deferral statute, it can sometimes count against you here. So know your record. And if you've missed those, it can be serious. There's also provision we were talking about in the problems. At several points in the statute, they talk about a conviction in the state. So what happens if there is a conviction from out of state? If I got 1 conviction from Indiana and 3 from Michigan, can I get rid of all the Michigan ones? Probably. If I've got 4 convictions, can I get rid of 3 of them and leave the least onerous one out there? That's to be determined. There's a really good argument that the answer is yes, but it's certainly not settled by a long shot.
Right.
One of the mathematical problems that we're seeing is, I shouldn't say mathematical, but chronological ones, is you've got to be 5 years for a felony or 7 years free from that conviction. What happens if there's an intervening conviction? Can you ever reach that point? So let's say in 2010, I was convicted of receiving and concealing stolen property as a felony. Then 2 years later, I pick up a drunk driving. Does that stop me in my tracks? There are some prosecutors who are getting prepared to say the answer is yes. I think they're wrong, but clearly this is a concern. We've even heard it from somebody in the Attorney General's office. So that's a problem.
Right.
I've got a gentleman who's got a felony conviction from the feds that followed the state, but the state conviction is hurting him far more than the federal conviction.
Right.
Does that federal conviction stop him? So these are questions that are going to be litigated. They're going to be appealed. They're going to be going to the Court of Appeals, and we're not going to know the answer until a higher court has spoken. And in the meantime, you could have courtroom 1 in a building have an answer of yes, and courtroom 2 in the same building with a judge who says, no, I don't agree with my colleague.
And that brings me actually to the next question. I will say this, my assistant and I have been researching this issue. We were told, before I get to the next question, that one bad night could be used more than one time. We were told by a representative from the Attorney General's office, folks, we'll let you know once we try it. Well, again, some of this stuff we're going to be trying out, and we'll find out what works, what doesn't work. But Stuart, have you been asked, because Tracy and I, we did interview Representative David LeGrand, who is one of the architects of the law, and I have said this, but that the judges need training. They're the ones that make the ultimate decision. Have you been asked to do any trainings? I think you guys probably be the dream team. Have you and Representative LeGrand, because he's a lawyer and he's an architect, and you have your background. Have you guys been asked to do any trainings with the judges?
I have not, but there has been judicial training through the Judges Association. I saw it on their website the other day, but I forgot who did the training.
Okay, well, I will be reaching out to my contacts because again, you can have trainings and you can have trainings, and I want to have trainings for people that deal with this stuff, that know the stuff. Like, so that's why we had Representative LeGrand. That's why we have you now, Attorney Friedman. I mean, we've had panels with people the politicians, the lawyers, but it's like we want to make sure that people get an understanding of this, because this is what Judge Thomas said when we first had the forum back in February. When we did panels in the past, we would go out and it was 1 felony, 2 misdemeanors, and you could give the people the form, and some people could go out and do it without a lawyer. This stuff, the lawyers are still trying to figure it out. So most of this stuff, I don't see the average layperson. You're going to need a lawyer. You're going to need a specialist to do this, because this is complicated.
Yeah, and prosecuting attorneys are having seminars where they're hearing new arguments to try to block it. There are a lot of people who don't like this legislation. And there are, yeah, well, thankfully, one prosecutor's office, which shall remain nameless, but is just north of 8 Mile Road, has had a change in leadership.
Right.
Yeah.
I do know that, oh, excuse me, Robyn.
Go ahead.
Were you going to say something? When Robyn and I conducted or moderated that expungement forum, I did raise a point to the Washtenaw County prosecutor, Ellie Savitt, about his colleague. I believe it's a Muskegon prosecutor, who said in a nutshell, hey, it's great, that the clean slate laws come about, but there's some, and basically this Muskegon prosecutor said, basically there's some people that don't have any business getting an expungement, and they, like you said, have a problem with the new clean slate law. So it's going to be interesting to see how it is received on the prosecution, and are they going to be blocking left and right? The Attorney General's office could block it, could object, as well as local prosecutors, correct?
That's correct, but typically, if it's not one of the rare prosecutions which is brought by the Attorney General, I'd say 98% of the prosecutions in the state are brought by a county prosecutor. 2% are brought directly by the Attorney General. Put that 2% aside. What they do is they look to see, are you statutorily qualified for expungement? Is there any conviction in there that says that you shouldn't be able to get it as a matter of law, that the statute is directly to the contrary? The prosecutors are going in there and arguing that the interest of justice quite often is against it. Yes, the judge, you have the authority to grant it, but here's why this guy doesn't deserve it. Right. And a friend of mine in Royal Oak today just told me that she had a judge deny one because the victim complained a lot and said that they're still traumatized by the offense. And the judge said that means it's not within the public interest. And some offenses, let's face it, some offenses are brutal enough, inflict hardships enough that we understand why they're coming from it. But sometimes it really just turns on whether or not you've got a crime victim who's got loud enough lungs or happens to be somehow related to somebody in the prosecutor's office or something like that. And that can cause a problem. And your opponent.
Right. I think that, as I do, having done these over the years, doing these forums, what I see is, there's evolution, because most of the time you do the forums, most people come, they're not eligible. Now you have more people that are eligible, but most of the people that are eligible don't necessarily have money to pay lawyers. So it's like we have a lot of progress to be made. And when you hear people's stories, I'm sure, Stuart, you've heard the stories, people who can't get jobs or people who are on their job and they can't advance on their job. So for these prosecutors that want to fight it, do they want to keep paying for the people, pay unemployment, or pay one way or another? You're going to pay. So to me, it just makes more sense to try to get, for those people who they made a mistake, they've redeemed themselves, give them a chance to get a job, to take care of themselves and their family. Otherwise, one way or another, you're going to be paying for folks. And you might as well, I just think redemption is the way. I mean, obviously, maybe there are some extreme cases, but most of the people I'm talking to are poor people, Black folk, people who made a mistake, and it's 10, 20, 30 years, and they deserve a chance. I mean, I think, most people deserve a chance. I know we're running on time, but I know we want to talk to you, Stuart, about, we had a Derek Chauvin trial. We had the verdict yesterday, and we have that George Floyd Policing and Justice Act. So we wanted to get your thoughts and reflections on that situation.
In the last minute, I'm sure.
Well,
I
Gotta go fast.
I am glad that the jury convicted him. I frankly couldn't see how, in any case I've seen, how he could have been acquitted. And I applaud, even though I realized it was because their back was up against the wall, the fact that the chief of police for Minneapolis came out and testified rather than backing his boys in blue. I think the Chauvin trial is telling, and it's hardly over. I mean, one of the problems that I've seen is that typically police officers who are accused of misconduct are the ones who get the most due process. Some of the most important cases in criminal justice have come when the courts have created new rights for dirty cops. And since we're then stuck having to use those cases to help our clients down the road, you feel somewhat ambivalent. But I think that people have seen in a lot of the conundrums, and there's been a lot of talk about the problems that we've seen with in the civil suits. We've seen the problems with immunity with respect to that a police officer, on one hand, we're supposed to trust them because they're the experts. On the other hand, we're supposed to give them qualified immunity because they're just cops and they don't know what they're doing. And we have the same people saying both messages at the same time. I find the act that you're putting up, I scrolled by him, the George Floyd Justice and Policing Act of 2020, which of course right now is still just a proposal, very helpful in that regard. I believe in training. I believe that we need to get rid of the military attitude that has overtaken so many police departments. We gave them military surplus hardware that was used in Iraq and put it out on the streets. And then we sit there and we get upset because they use it like they're in Baghdad, and they're not. If you look at a beat cop, sorry.
go ahead.
Well, I thought, Stuart, it's interesting that you raised the point about law enforcement, police officers receiving more due process than the average criminal defendants. Police officers find themselves like Derek Chauvin prosecuted. There's that whole movement for the Police Bill of Rights. It got, shot down, no pun intended, in Maryland. And this is what I want to ask you in the waning moments. So you specialize in criminal appeals. So based on what you saw during the Chauvin trial, there is talk that Derek Chauvin is going to mount an appeal. Did you see anything that would give him a basis? Did Eric Nelson make a good record as a basis for appeal going forward? This is what people are worried about.
Well, I think he did. I think in quite a bit of that case was actually tried for appeal, to be honest.
Yes.
And he wasn't a stupid man. He knew that he probably had to live to fight another day, and I'm not going to criticize him. I've done the same thing in other cases.
Right.
Obviously, his first issue is going to be that the jury should have been sequestered.
Do you think the jury should have been sequestered? Eric Nelson did make a motion, and he also made a motion for change of venue, and Judge Cable shot it down. He denied it.
The judge also did some protective measures, special instructions to the jury, etc., to try to address some of these concerns. But it's a perennial problem. This case is absolutely everywhere you look and everywhere you turn your head. And I think the trial judge made a mistake in that he told them not to the juries to look at news about the Chauvin case, but didn't predict the is it Brooklyn Heights, Minnesota? I forgot the exact city.
Brooklyn Center.
Yeah,
Brooklyn Center
Dante
shooting,
Rice.
which they were fully free to look at. And I'm sure he's going to get quite a bit about that. The judge invited him to file a record of all the media attention in this case, to make a record on appeal. And I expect they'll probably need to use a Mack truck to bring in all the media exhibits that they need. So that's going to be a complicated issue. But I was looking earlier today, and Minnesota says if the judge takes some protective measures, they're given a lot of discretion. But I don't know. I mean, I look back to the Butson and Nevers case, Malice Green shooting, and that's where we sat there and drilled down about all the adverse publicity here.
Right.
Like I said, police misconduct cases often are the ones that judges seem to be the most troubled about due process about. So I think it's a legitimate concern. The motions in limine, and there were plenty of them to keep out various evidence, potentially an issue. I expect that there's going to be a fight on causation. I don't think that it's going to go anywhere, but that's my prediction as a Michigan attorney interpreting other law. But what is the appropriate level of contribution that Officer Chauvin had to do to the guy's death? Is it a substantial cause? Is it a significant cause? Does it have to be the only cause? You were talking about Mr. Nelson. I think he misstated that in his closing arguments, and I think he deliberately tried to blur the lines. But if he accelerated the man's death by 5 minutes, from the way I read Minnesota law, that's sufficient to convict.
Right.
But there's going to be a big fight about that. The law has always been that you take your defendant as you find them. We learned about in law school about the eggshell plaintiff, and that was in
vulnerable victims. Yes.
Yeah. So the fact that I choose to attack somebody who's got a bad heart doesn't mean I can say, well, don't blame me if I hit Mike Tyson, he could have taken that punch, but because this guy had a bad ticker, it's not on me. And I think that's going to probably go nowhere, but I anticipate that's going to be an issue.
And what about the fact that they gave the settlement, they announced the settlement right at the beginning of the trial, what's 27 million or 28 million right at the beginning? Like, do you think that I think that would be raised as an appealable issue, but do you think it'll go anywhere?
Well, as I recall, they still had a chance to voir dire on that. I'm not 100% sure. But
I think they did too. But what about the, it's been said that those jury instructions were rather confusing. I don't know if that's something that you looked into. I believe that was in connection with that third-degree murder charge. There was some back and forth about that between the lawyers. What's your take on that? Hot take on that?
Well, the third-degree murder charge was also was reinstated by the Minnesota Court of Appeals.
Right.
So you already have a ruling on that, which limits their ability to go after that in front of the Minnesota Court of Appeals, though they could theoretically raise it again in the Minnesota Supreme Court. With respect to the elements of third-degree murder, that's a distinctly Minnesota issue. Some at a little bit of a disadvantage. Michigan's got 2 degrees of murder. They've got 3. And the difference between the various degrees turns on very, very fine points. I mean, we're talking about levels of indifference, and they didn't.
Wasn't there also a question about whether having to do with multiple parties or an individual party, as I recall, there was some gray area in the statutory language.
I'm not prepared to speak about that point right now.
Okay.
I've looked briefly at the pleadings that are filed, and the state of Minnesota has them on the court website. You can look at all the pleadings that were filed there. But to become an expert on that issue would have required days, not hours.
Right, but finally, and I appreciate that response, but finally, what did you think of the job that Eric Nelson did? And as a last resort, Chauvin could use as an appellate issue ineffective assistance of counsel. Some have criticized Eric Nelson for, not making enough objections to all of that emotional testimony that Judge Cahill let in.
Ineffective assistance of counsel is a very difficult issue. The first question you need to look at is whether the attorney properly researched the file, whether it was investigated, and therefore whether it was strategic. If the decision was based on his decision that I don't want to look like I'm afraid of the evidence, I'm willing to let that one go, it's very, very tough. One of the things you need to know about ineffective assistance of counsel is the question isn't whether you got the representation you paid for if you bring in this out-of-state high-end talent and have multiple attorneys, but whether or not your attorney met the standards of the average court-appointed attorney practicing in that district. And I think he got far beyond that.
Right.
I think that courts are going to be very nervous about ruling that it was ineffective for the very reason that you're going to be increasing the burden on so many other attorneys in that regard. I think if they're going to turn around and touch that issue, they're more likely to do it on manifest injustice, which is also an exception to failure to object. And the law is incredibly vague about when you've objected to two things along the same track, and then a third thing on the same path comes in, and you've already had the ruling, which makes it clear the judge isn't going to stop you. Is that sufficient? We have that fight also about what's called continuing objections.
Right.
Judges said you've objected enough. You've got a continuing objection to all this testimony. And then you'll see on appeal, they'll say, but this was just a little bit different than that, and therefore it's not good enough. And this is usually from judges who say, keep it civil, you don't need to sit there and do a 360-degree assault on that. And it's the same judge on a different day. That's the thing that drives us as appellate lawyers crazy. Right. They tell you they want civility, but when they can duck a question they don't want to answer, they change up the rules.
Right. And then, Stuart, real quick, I know we're pressed for time. We appreciate we've gone a little bit over. I appreciate you giving us this time here. What do you, and this it's not necessarily like a legal expert, maybe more legal or political strategy. What do you think it will take? We have this verdict, we have somewhat the will of the people, but to actually get the passage of the George Floyd Police and Justice and Policing Act, what do you think it would take to actually, because we know they have to have 60 in the Senate. You'd have to have, you need to get some of the Republicans to come over. Maybe you can get some of the retired folk or people are going to retire to come up. What else do you think? What if I'm in the audience now? I know Tracy at the outset said to call your local, your senator, your two senators. What do you think it will take to push us over the edge and actually get it into the hands of the president?
Well, I think you hit the nail on the head when you said we need to figure out how to pull some Republican votes. And one of the things that I think the Democrats have discovered is that the Republicans have done a much better job than we have about stopping most of their senators from voting against ranks. So it often turns down to Murkowski or I forgot the other Senator Collins or a couple others. And what troubles me here is look at the districts they're coming from. Look at where they're coming from. Look at the demographics. That's not going to be where they're going to have as much permission to go against the ranks. You break ranks when you think that your base will support you. And neither of them are from urban areas. What kind of problem do you think we have with this going on in Maine or Alaska?
Okay.
Right.
That's
Excellent
my
point.
fear. And we're expecting in 2022 a very difficult race to hold the House.
Yeah,
So I'm
definitely.
delighted this bill has been passed, but I'm not going to sit there and assume that we've got wonderful chances right now. We can't get gun reform through after mass shootings. We can't get anything. You know, it is very, very difficult. And we've got some very Republican leaning senators who are Democrats from swing districts who are going to be in a difficult position there. You drive through those districts and you see all these signs up about support our police, or that black and blue version of the American flag we've all seen.
Right.
You know, that's the problem I said with politics with pardons. At the end of the day, politicians are motivated by self-preservation, and you need to create a comfortable enough zone for them to feel comfortable getting on board. And I'm not sure that we've got it right now. I hope we do. Only time's going to tell.
Right.
Right. That's a great way to end it. And you've
Yes.
been listening to Stuart G. Friedman. He's been dubbed a super lawyer, super attorney, crimmigration lawyer. Hey,
Immigration,
how do people get in
expungement,
touch with you?
pardons.
How do people get in touch with you, Stuart, for advice and counsel on pardons and expungements?
Well, my website is www.crimapp for criminal appeals. That's CRIMAPP.com. My telephone number is 248-228-3322. My email's on my website, so I'm not sure if people want me to spell that too.
Okay, we'll add that. We'll
Fantastic.
add that to the link for the Facebook and the YouTube and, you know, everything. So, so thank you, Stuart, Attorney Stuart Friedman, super lawyer, Mr. Legal Expert. So this has been Attorney Robyn McCoy and Attorney Tracy Martin with Political Coffee with Robyn and Tracy. I still have my Batman mug. You know, I wanted to show Batman some love. I know I've been showing Wonder Woman some love. We got Tracy with her mug and Stuart with his. So thank you, everybody. And Stuart, this has been a wonderful conversation. We've had a chance to pick your brain. I'm sure we'll want to have you come back. Maybe we'll have you come back to talk about immigration, because immigration
Yeah,
is
please do. It's
Well,
such
thank
a
you.
hot topic.
It's been fun, and one of the nice things about Zoom is you don't have to travel too far for these interviews.
Right.
Thank you.
So you have a
Thank
blessed
you.
day. And again, thank you for everything. Thank you for your time.
Take care.
Okay, you too.
Thanks, Stuart. Bye, everybody.
See
Don't
everybody
forget to call your U.S. senators. Call.
Yep,
George
call
Floyd
them.
Justice and Policing Act, HR 1280. Call today, tomorrow, next
Call
week.
them.
Call.
Twitter, tweet them. Hey, all of it, all the above.